Let's see. All right. Well, welcome and thank you for joining us this afternoon for a special presentation from attorney DJ Jeyaram of Jeyaram and Associates in the Metro Atlanta, Georgia area. DJ specializes in wills and special trusts, special needs trusts, guardianships, and estate planning. In addition, DJ serves as a part-time judge for the Gwinnett County Magistrate Court. DJ is known for being a great friend and advocate to the special needs community, as he too is the father of a special needs child with a rare condition. His firsthand knowledge makes him an amazing advocate for those of us on the same journey. Today's presentation of Special Needs Trusts and Guardianships is presented on behalf of the SATB2 Gene Foundation. To learn more about our foundation, please visit us at SATB2gene.org. There will be time for questions at the end. Please post any questions in the Q&A feature found at the bottom of your screen, and we will get to those at the conclusion of the presentation. And now I'll pass the controls to DJ. Thank you.
Thanks, Allison. I'm going to go ahead and start with sharing my screen here with some slides that'll kind of make it easier for everyone to follow along. You know, I have to say this, even though I am an attorney, just because we're watching this presentation or looking at the slides, we have not established an attorney-client relationship. So if you need specific answers, I do urge you to find an attorney in your area that specializes in special needs estate planning. I am barred in Georgia, Massachusetts, and California. The examples I'm going to give today are really based on Georgia law. It may differ a little from state to state, but the overall concepts we're going to discuss today are going to be applicable no matter where you live. Just a little bit about my experience. Again, as Allison said, I work as a part-time judge here in Gwinnett County. I also have a healthcare regulatory practice along with my special needs estate planning practice. I went to law school at Emory University in Atlanta and just ended up staying here. And all that really is just kind of what my legal background is. I've been practicing about 23 years. But really kind of the most important thing is this is the reason why I do special needs estate planning. This is my son, Kai. Kai has a condition called Williams syndrome, as speech challenges, physical, occupational therapy, feeding issues, sleeping issues. We kind of have the grab bag of challenges. The reason I bring this up is as an attorney, I approach planning for families in this presentation from a parent's perspective first. You know, I think a parent has to understand and come up with what their goals are in this estate plan, and then the attorney can help them legally get there. But it really needs to start from a place of understanding what your personal goals are. Now, what are the goals for today? One is really just a common sense understanding of what documents you need in your special needs estate plan, the major factors in choosing the key players in your estate plan. It's really not as easy to choose the players in the plan as it is in a typical estate plan where you don't have special needs kids. And finally, how do you know if the attorney you're talking to is the right one for you? You know, attorneys are generally trained to be persuasive. And so you really want to talk to an attorney who knows what they're doing in the special needs arena rather than someone who just generalizes and is kind of selling you on experience. So let's go ahead and get started. This is the list of what you need in a good special needs estate plan. Obviously, everything starts with a will. I'm going to talk about every one of these documents and the choices you have within them. Everything starts with your will. The other major component is that of a special needs trust. So today we're going to talk about what it is, what it does, what you can use it for, and ultimately what your major choices are in creating the trust. The next two documents, an advanced medical directive and a financial power of attorney, are very basic estate planning documents. You'll have those even in a regular estate plan. We're going to talk about HIPAA waivers, legacy statements, a letter to the guardians. A letter to the guardians is sometimes also called a letter of intent, which is really kind of just the plan to take care of your child if something were to happen to you. Child safety and protection cards, and we're going to spend a little time talking about choosing guardians, guardianship designations. One thing I'm not going to talk about today is how to avoid probate. A lot of attorneys, a lot of financial planners and CPAs will tell their clients you have to avoid probate at any cost. That's really a state-specific question. In Georgia, it's not so important. Probate's not that big a deal. In New Jersey, where my parents are, or out in California under California law, a probate can be long and expensive, so maybe avoiding probate would be a better idea in those states. But that really is something you need to speak to an attorney in your area to see if that's the right choice for you. All right, let's dive into the documents. All right, so I don't have a slide for the will because the will is really pretty simple. You're going to have just a few major choices in your will. One is, how will your estate flow? You know, who gets the money and what percentages? Two is going to be the choice of guardians. If you have guardianship over your child or your child is a minor, you're going to have to choose guardians in your will. And three, depending on how we set up your special needs trust, you may name your trustees in that document. So those are really the three major choices. There are several others, but really those are the big ones. The question of how your assets will flow does become a little more complicated if you have a typical child along with your special needs child. What you would need is a separate trust for each of them if you want a trust for your typical child. Whatever you leave to the special needs trust cannot be shared with the typical child. So as you'll see as I discuss trusts, I use the analogy of a bucket. You'll have a typical bucket and a special needs bucket, and they really will not mix. But I'll talk about a little bit more about that in a minute. So special needs trusts, well, what are they? Well, first we have to understand what a trust is. A trust is just a legally created entity, almost like a corporation, that is meant to hold assets. That's it. That's really what the trust is. Now, within the trust, you, as the creator of the trust, will make certain decisions on how the money in the trust is to be used. Now, the person who carries out those decisions is called the trustee. In a regular trust, depending on state law, but in a regular trust, you generally have a lot of discretion on how that money is to be used. In a special needs trust, it's a little more limited because, as you'll hear in a second, we will have to comply in the drafting of that special needs trust with Social Security regulations. So back to a special needs trust. What makes the special needs trust special? What does it do? There really is only one answer to that, and it is to preserve the beneficiary's ability to get resource-based public benefits. Well, what does that mean? Well, a resource-based public benefit is essentially Medicaid, if you have Katie Beckett waivers in your state, and SSI. Those are the three types of public benefits that look at what the resources are in your child's name and what their income is. So what makes a special needs trust special is you leave assets meant for the care of your special needs child, whether that's through your estate or other means. and you leave it into the special needs trust. The government ignores what is in that special needs trust in determining your child's eligibility for SSI and Medicaid. There is no limit to how much you can put into a special needs trust. The real key is to make sure that it is properly drafted. And if so, the government, this gentleman here in the picture is supposed to be the government, will not see what the money that's in that bucket. They know it's there. You do have to disclose it when you apply for SSI and Medicaid. And they will ask to see a copy of it to make sure it's properly drafted. But if properly drafted, you could have $10 million in that bucket and your child could still qualify for SSI and Medicaid. So that's what it does. That is really it. Now, if you're in the situation where you have a child, a special needs child that may not qualify for SSI and really seemingly will never qualify for SSI because they can hold meaningful employment or really for whatever reason, well, then if you're not going to qualify for SSI and Medicaid, you do not need a special needs trust. Now, you may need a regular trust just because a special needs child may not qualify for a special needs trust doesn't mean that they're able to manage their finances appropriately. So even if you don't qualify for SSI and Medicaid and may never in the future qualify for it, you still might want to contemplate a regular trust for your special needs child just to make sure that the assets you leave for them are being protected and used appropriately. Okay, so there are three major kinds of special needs trusts. The first one's called a first person, also known as a self-settled special needs trust. Now, the reason it's first person is the assets in that trust are from the beneficiary themselves. It's from the special needs person. So what you would be doing, and I'm just going to use my son Kai as the example. Let's say a grandparent left $10,000 to Kai. Well, that's now in his name. He legally owns it. He's entitled to it. But I don't want that in his name because that's going to affect his SSI and Medicaid. So you remove the money from their name and you put it into a first person special needs trust. Now, the downside to a first person special needs trust is anything left in the trust at the end of Kai's life, Medicaid can take to the extent that it has paid for any services for Kai. Now, Kai's been on a Katie Beckett waiver and on Medicaid because of that since he was, just a few months old. So he's been getting a lot of Medicaid-based benefits for that period of time. If we were to have to pay back everything Medicaid's paid, whatever's left in his trust would probably be depleted. The second kind of special needs trust is called a third person special needs trust. This is literally any assets that are not in the individual's name. So it's assets that I leave for Kai, but I leave it directly to the trust. I don't leave it to him. Grandparents leave it to the trust. Life insurance leaves it to the special needs trust. It never hits his hands. He's never legally, personally entitled to it. So that makes it third person assets. So the good thing about a third person special needs trust, there is no Medicaid payback. Now, what does this all mean for practical purposes? Well, for practical purposes, if you plan ahead, before money is heading towards your child in any capacity, if you plan ahead, whatever special needs trust you set up will be third person. If you don't plan ahead, or a mistake is made, goes to your child, the first person special needs trust is a way to correct that mistake. But the price that you pay for that is the Medicaid payback at the end of the life of the beneficiary. So all that just to say, if you speak to your estate planning professional, make sure you tell them, look, we want a third person special needs trust because none of these assets are in my child's name, okay? Generally, a third person special needs trust, again, the money can come from any place, but generally you see it from an inheritance that parents want to leave out of the child's name. In your will or your estate planning documents, instead of saying 50% to Kai, it will say 50% to Kai's special needs trust. Same thing with life insurance. You want to make sure that if you have it, once you have a special needs trust created, that the life insurance designates the trust as the beneficiary, not the individual. So in my life insurance, if I say, 100% to my wife, but if she is predeceased me, 100% to Kai, even if there is a third person special needs trust out there, that's not where the life insurance company is going to send it. They're going to send it to Kai. Then I will have to take it out of his name, create a first person trust, and put it in there. So it's very important to get your life insurance designations correct. The final type of trust is what's called a pooled trust, a pooled special needs trust. And essentially what that is it's a group trust. These are trusts that are run by professional trust companies. And essentially what you do is it's a giant trust, and you would open an account within that trust for your child. Now, pros and cons to these choices. There is no pro to a first person special needs trust, other than you're recovering from making a mistake. That's it. Now, the pro and con of a pooled trust. Well, one is the trust document. I find this to be a con, but the trust document itself is already drafted. The rules are drafted, and it's been approved by the state and the feds, and it's ready to go. You do not get to make the choices on how that money's to be handled. That's already been made for you. Second, the second con to the pooled trust is, I find that the individuals who are actually handling the trust, the trustee, who's that company, sometimes they'll have a family member as a co-trustee, but they don't know who your child is. The first person might when you first open the account, but when that person gets a better job and moves on and somebody else moves in into that position, they may not know who your child is. And, personally, and again, parent perspective, I want whoever's handling the money to know my child. Even if it's a professional, they at least have to know what he looks like, a little bit of what he's about, a little bit of what his challenges are, who he is. I think that's important in knowing how you as parents would want them to handle the money. Now, the pros of the pooled trust. The pro is you have all of the expertise you need on a special needs trust under one roof. So you will have a CPA under that roof to file tax returns on behalf of that trust. You will have somebody who understands the Social Security regulations under that roof. You'll probably have a financial planner under that roof. So there are definitely some pros and cons. Obviously, with the pooled trust, you are paying you got to pay that company to manage it for you. With the third and first person special needs trusts, your trustees, even if they're family members, are entitled to compensation for being trustee. What I've found in practice is especially in a special needs trust, most family members and friends just waive that fee and they leave the money in the trust for the care of the child. You can't expect a pooled trust to waive that fee. You know, they obviously have to pay their people. So those are the three major categories. You do not want a first person special needs trust unless you're trying to recover from something. Third person, if you want it specific to your child, third person is what you want. If you don't have the means to pay an attorney to create and draft a special needs trust specifically for your child, you may want to look into the pooled trust. You know, it tends to be less expensive to create, probably more expensive to maintain. All right, so we know what a special needs trust is. It preserves benefits and the ability to get benefits like SSI and Medicaid, and we know your major choices of the type of special needs trust. Now we're going to talk about how do you create it? You know, how is that special needs trust created? This is something that whoever you talk to should speak with you about, okay? You don't want an attorney telling you which type you want. So let's discuss the two types. The first type is called a testamentary special needs trust. Now what that means, all testamentary means is in your will. It's created from your will. What happens is when generally if you have spouses, the spouses will leave 100% to the surviving spouse. And then whichever spouse is left when they pass, the money would go into the special needs trust. So what happens is when the second spouse passes, in your will be drafted a very detailed blueprint of what your special needs trust will look like. All the decisions that mom and dad as creators of the trust need to make have been made and are drafted into that blueprint. Once you've passed, whoever the executor of your estate is will read your will. They will say, look, there's a blueprint for the special needs trust, and then they will go to an attorney that specializes in that area and say, look, all the decisions have been made. Here's the blueprint. Just draft it up for us so we can put some money in there. The other option is to create it now. You know, again, back to the bucket analogy. In a testamentary trust, it's a blueprint of the bucket. It's not the bucket itself. Creating it now, you're telling me, DJ, look, I don't want a blueprint. Go get me that bucket. You know, I want the bucket sitting on the table right now. So if I decide I want to put money in it before I pass away, I can. If a grandparent wants to do it, if an uncle wants to do it, they can all use that bucket if you've created it now, as long as they've designated it properly in their will. So pros and cons to both. Generally, the testamentary trust, drafting of it is cheaper because you are getting the blueprint. You are not getting the bucket, okay? The second big benefit of the testamentary trust is if you plan on leaving the state you're currently living in, where you had your will drafted, and you move to a new state, well, that blueprint will travel between states better than a trust that is already drafted. The reason for that is, think of it like building a house. If you have the blueprint to build a house and you build it in California, it will be built to code in California using the same blueprint. If you moved to Georgia, I could take that same blueprint that was created in California and build it to Georgia code. So all the major conceptual choices are still good. We're just going to build it to code in the state when you need it, once you've passed away. The biggest benefit to creating the trust now, there are really two of them. One, I alluded to, and that is if you want to take that bucket and put have grandparents, aunts, uncles, anyone else who wants to leave money to your special needs child for their care, if they want to do that, they can leave it to that bucket. Now, you can't do that with testamentary because let's say it's a grandparent. But the grandparent passes away before you do, and you have a testamentary special needs trust in your will. It doesn't exist yet, just the blueprint. So that bequest from the grandparent into that special needs trust, since it does not exist, that bequest would fail. The second reason really is, honestly, it keeps your executor from screwing things up. You know, you all are either listening to this live or listening to it on a recording. You are obviously taking time to learn and educate yourselves about special needs planning. We don't know if your executor has that background. We don't know if they're going to care. You know, drafting a special needs trust is more complicated than drafting a regular trust. I have had people call me with a testamentary trust, ask me how much it would cost for me to draft the actual special needs trust. And I will quote it to them, and they would say, well, that sounds like too much money. You know, my Uncle Bob's a real estate attorney. I know he does land trusts. I'm going to have him do it. That's dangerous because Uncle Bob's not going to be educated on the Social Security regulations. They're just not, there's no reason for him as a real estate attorney to know those. And the risk you run is if Uncle Bob makes a mistake and that first person or that third person special needs trust fails, the only way to recover is to put it in a first person special needs trust, which of course has Medicaid payback. It's kind of going back, one question you all might have is, in a third person trust, when the beneficiary passes away, who gets the money? The answer is the same for the pooled trust and the third person special needs trust. It goes to whoever you decide it goes to. It does not go to Medicaid. So it can go to a typical child. It can go to their, to their kids. It can go wherever you choose it to go. So pros and cons to both. Candidly, as a special needs parent, I really don't think there's such a thing as a wealthy special needs family. If you're going to have to support your special needs child for the rest of their life, even if you have money, you want that to go to them. You want it to go to your kids. And so the least expensive way to get where you need to go in the short term is the testamentary trust. You're kicking the cost of the drafting of the actual trust down the road after you pass away. And at that point, all of the assets of your estate are available. You pay the attorney just to draft the trust. So, testamentary is sometimes a good way to go. Just know that if you do create the trust now, it springs to life when you put $1 in it. Once you reach a certain dollar amount, which is not very much, you're going to have to start filing tax returns. And the role of the trustee and reporting requirements starts right away. So there's some paperwork involved year to year if you create the trust now. All right, so we know what a special needs trust is, what it's meant for, the types, first, third, pooled, and we know the two ways to create it. You can create it now, which is standalone living trust, or you can create it as a blueprint in your will, which is the testamentary trust. All right, here's the big one for parents that do even have special needs trusts in place. What can you use it for? What can't you use it for? And this is really important to understand, because if you don't understand this, what you have is the attorney's plan for your child. You don't have your plan for your child. So generally, what can you not use special needs trust funds for? You generally cannot use it for food or shelter. And the reason for that is SSI is thinking, well, look, if you're 18 or older, we're letting you have that, $2 million special needs trust over there. And we're still going to give you Medicaid, and we're going to give you a monthly SSI payment. You need to use the monthly SSI payment for food or shelter. If you use funds from this special needs trust for food or shelter, it can reduce the cash payment to your child. Or if the use of the special needs trust funds is to a certain amount, it could even terminate your child's benefits. So it's important to keep an eye on that food or shelter concept. Now, I know what you're thinking. It's the same thing I thought when I first heard you can't use it for food and shelter. Well, what good is it if you can't use it for food and shelter? Well, what can you use it for? Well, you can use it for anything but food and shelter. You can use it for support services in the home. You can use it for out-of-pocket medical and dental, vacations, furnishings, vehicles, hobbies, education. There are going to be legal and accounting fees associated with your trust. You can pay that. Cell phones, non-food grocery items, pets. I know as our kids age, one of the big questions is, what do we do with them when they get out of school? Well, you can use those funds in the special needs trust to start a business for them. You can do a lot of different things with that money. Now, how do you solve the food and shelter problem? Well, I'm going to talk about ABLE accounts. For those of you who don't know, ABLE accounts work very much like a special needs trust, to the extent that anything you put in it, the government ignores in determining your child's eligibility for SSI and Medicaid, okay? So in that way, it's the same. The reason you can't use an ABLE account in place of a special needs trust is you are limited with one very minor exception I'm not going to go into, but you are limited to $15,000 per calendar year deposited into the ABLE account. Now, most people's estates, including life insurance and everything, are more than $15,000. So an ABLE account can't fill that role of a special needs trust. The beauty of the ABLE account is you can use those funds for food. Okay? You can use it for shelter if the money is spent in the same month that it is dispersed. So say, Kai has a condo, and I write him a check to pay to his landlord for $650 in June, and he pays it to the landlord in June. That money's not counted against him, okay? Now, if I give it to him in June, but he doesn't pay until July, then it's counted against him. So there are some permutations that whoever is handling the ABLE account for your child needs to understand. But bottom line is you can use an ABLE account for food, and you can use it for shelter with no penalty if it's handled correctly. So in that way, you have a lot more flexibility with an ABLE account than you do with a special needs trust. The other really good thing about the ABLE account are their financial benefits to it. It works just like a 529 account. Post-tax dollars in, it grows tax deferred, and then if it's used for an allowable purpose for your special needs child, which is really just about anything that will help them with their special need, then it's tax exempt. That deferment becomes an exemption. That is a really nice tax benefit that a special needs trust does not have. Some states will allow parents to write contributions to a special needs trust, write it off as of their taxes. Georgia's not one of them, but you would want to check with a CPA or an attorney in your state to see if you might have that benefit. One major downside to the ABLE account, and that is at the end of the life of the beneficiary, there is Medicaid payback. Anything left in the ABLE account, Medicaid can take to the extent it has paid for any services for your child from the date the account was open until your child passes. So that's a little different than a special needs trust, even a first person special needs trust. First person special needs trust, Medicaid payback is from the beginning, services Medicaid's provided from the beginning of the life of your child to when they pass. ABLE is from when you open the account to when they pass. So just something to keep in mind, there is Medicaid payback for ABLE. All right. So that is really it for special needs trusts. We know what makes it special. You're protecting your child's current and future eligibility for SSI and Medicaid. What are the major kinds? First, third, and pooled. You don't want first unless you're recovering from a mistake. Pooled is an option. Third is if you want that trust particularly drafted for your child, then you want a third person. You know when to make it. Make it now, make it later. There are pros and cons to both choices. And we now know what you can use those funds for. ABLE is a really nice ancillary to your special needs trust. The way we draft our trusts, and I encourage you to check in your state, whoever drafts your special needs trust, make sure that your trustee for your special needs trust has the ability to take trust funds to fund an ABLE account. So that way they can take advantage of those tax benefits and take advantage of the flexibility to pay for food and shelter out of the ABLE, even though the money initially came out of the special needs trust. So that is it. I'm going to move on. I'm going to ask that you all hold your questions to the end. So just jot them down, and Allison will make sure she gets them to me. All right, I'm going to talk about guardianship. So the very basics. Who needs a guardian? Anyone under the age of majority. In most states, that's 18. So anyone under the age of 18, typical, special, doesn't matter. You need to appoint a guardian if something happens to you. Any incapacitated adult who's reached the age of majority if they meet a certain legal standard. And so a court, in most states, a court has to adjudicate somebody incompetent before they can qualify for a guardian. So you have to go through a legal process, even if you're the parent. So in Georgia, the way it works, in most states how it works, is your child turns 18 and they're an adult with all of the rights and privileges of being an adult in your state. They can make all their own decisions. You cannot make their decisions for them, and they can certainly overrule anything you try to do on their behalf. Guardianship, you are taking away rights from that individual, okay? And you're basically, I like to say, you're freezing them in time at the age of 17 in terms of their legal rights versus your ability to make their decisions, okay? If they are not adjudicated incompetent by a court, they have all their rights. It does not matter if they have an IEP, it does not matter what their IQ is, none of that matters. They have all of their rights, okay? Now, big question I get about guardianship is, well, I don't want to remove my child's rights. You know, I want to empower them to keep their rights. And that's great. I think that's a laudable goal. I get asked about powers of attorney as a option other than guardianship. Power of attorney is when your child, your adult child, 18 or older, is appointing you as their agent. You will exercise their authority in their name. They do not lose any of their authority. They just let you exercise it for them, okay? For those of you who have kids who are high functioning and may not even reach or meet the standard to get guardianship in court, power of attorney is really kind of the way you want to go, okay? Because it'll still enable you to help your child with all of those decisions. Now, they can overrule you. You know, I like to use the example of getting wisdom teeth out. You know, with power of attorney, if, you know, the orthodontist and the oral surgeon and dentist and all those people say, look, they need to come out, and you tell your child they need to come out, and your child says, nope, I heard it's painful, I don't want them out. At 18, under power of attorney, those teeth are not coming out because you are their agent. They can overrule you. In guardianship, again, subject to state law, you are making their healthcare decisions. Okay, you can generally overrule them. The standard for guardianship across the states, it differs from state to state, but is generally along the lines of the individual is unable to make unable to make or communicate reasoned decisions about their health, education, safety, and welfare. Okay. Well, what does that mean? As a practical matter, it means things like, do they understand how much money is? Do they know a gallon of milk is $5 and not $50? Do they know how to make a doctor's appointment? Do they know how to fill a prescription? Do they know how to make food? Do they know how to use a stove or a microwave safely? Will they recognize danger to their person? Are they susceptible to be taken advantage of? Now, any one of these things is not enough. All of these factors are a balancing test. Many courts, if you go in for guardianship, will ask, did you try power of attorney first if you have a high functioning individual? So just be prepared to answer that question on why power of attorney was not appropriate, or if you've tried it, be prepared to tell the court why it didn't work. So let me talk to you more as a parent for a second than an attorney. And to me, the question of guardianship comes down to entering into a contract. Do you want your child to be able to enter into a contract? The story I'm going to tell you is true, and it's an older story. It was from the 80s, and it was back when credit card companies would call you normally around when you're sitting down for dinner and try and give you credit cards over the phone to sign you up. This family had a high functioning individual, and the son, who was over the age of 18, answered one of those calls, and of course the salesperson kept saying, well, you know, do you want a card? You know, $500 credit limit. You know, after the first month, it goes up to 1,000, and, you know, no payments for the first 12 months. You know, do you want free money? It was that kind of sales pitch. And, you know, the son said, yes. And well, they mailed the credit card to him, and knowing that he was, you know, over the age of 18. And one of his chores for the house was to get the mail and bring it in. So he intercepted the card, and long story short is he used it, and he ran up about $1,000 worth of charges. You know, all of a sudden, you know, he had friends he didn't have 30 days before. People could smell the fact he had the credit card. My understanding from the parents was he kind of bragged about it, and, you know, people saw that and took advantage of it. Well, the parents when the parents finally caught wind of it and saw the bill, they called the credit card company and said, look, you know, he's a special needs individual, he has an IEP, you know, he has an IQ under 80, you know, here's his diagnosis. And what do you think the credit cards companies reaction was. The reaction was, oh, we're so sorry, when do we get our money? Now, if there was guardianship over this individual, that contract is void from inception because that child never had the ability to enter into the contract. It'd be the same as a 12-year-old entering into a contract. It's void. Now, can the parents get out of paying for that money without guardianship? Maybe. They'd have to, get sued by the credit card company, and their defense would be that, look, my child lacked capacity to enter into the contract. Well, the credit card company certainly is going to have an attorney. That family's probably going to need an attorney. Well, how much do you think an attorney is going to cost? Well, it's going to probably more than that $1,000 that they could just pay the credit card company. So they're kind of in a lose-lose situation. By no means is that the only consideration. For me as a parent, though, that's what I'm afraid of that. I really am. I mean, making of doctor's appointments and, pharmacy, my kid wants me to do that anyway. The money, that freedom that represents to them, the fact that it will, a lot of our kids are desperate for friends. And, if they understand, if I just show some money, these people will pretend they like me, I worry about them being taken advantage of. So that's just one of the practical considerations in guardianship versus power of attorney. When do you start the process? We always advise 17 and a half, make the call to an attorney or start looking at the law in your state, figure out when you can file the petition for guardianship, and figure out whether it's something you want to do on your own or whether you want to engage legal counsel for. In some states, you're required to have attorneys, and some you're not. In Georgia, you are not required to. And, frankly, if you have a uncontested guardianship situation, there's no parent or physician or sibling that is objecting to guardianship, or the individual themselves, your child is not objecting to the guardianship. I always advise parents in Georgia that, with a little training, they can do the guardianship process themselves without an attorney. Okay, so that's a guardian. So choosing a guardian, it is not as easy to choose a special needs guardian as it is a typical guardian. One is you're planning potentially, depending on your child, for the rest of that child's life. You're talking about guardianship for a long, long time. With a typical child, it's just guardianship till 18. So, you might not have a guardian in place that long for a typical child. Do they have the energy? Can they do what they need to do? I'm an older parent, and I barely have the energy to take care of my kids and my special needs child. Certainly, I can't have my parents do it. They're in their 70s, and are they going to be able to do everything that needs to be done every day? It's exhausting to do what we all do. I don't think anyone has a different opinion on that. We're tired, and it's stressful. What is the health of the guardian? Do they have their own health conditions? Do they have their own kids with health conditions? One thing I hear a lot of is, look, my guardian has a special needs child, so they understand the special needs world. Okay, that's great. Can they handle it? Can they handle two special needs kids? I know I've got one special and one typical, and I can barely handle that. You threw another special needs kid on top of that, I think I'd probably lose my mind. It's, it's hard. And so you want to think practically, can they do it? Not in theory, will they be a good choice, but in practicality, will they be a good choice? Do they have an established relationship with your child? Do they know them? A lot of times we get people who come in and just automatically default to a grandparent or an aunt or an uncle or someone of that nature. And it's understandable. You know who they are and their family members. But if that grandparent or aunt or uncle lives in California and you live in North Carolina. Does that make sense if they only see the child once a year? You know, is there a relationship there? Location is a big one, a big one. That same example I gave you of North Carolina and California. Well, you have to ask yourself the question, in that situation, if your guardian is in California, is your intention for your child to move to California to live with the guardian there? Or is there a chance that the guardian can come to and live with the child in North Carolina? The reason that's important in the special needs context, our kids thrive on consistency. And you really do have to put it in context. And the context is mom and dad are not there one day. You know, something has happened. And obviously I'm talking about worst case scenarios. But if you want your child to move to California, not only are mom and dad not there, but then you're removing the child from the home they've known. You're removing them from the neighbors and the teachers and the therapists and the caregivers they know. You know, hopefully they've made some friends. We know how hard that is for our kids. Well, they're being removed from their friends. So not only did they just lose mom and dad, but they've lost really everything that's surrounding them. You know, maybe a sibling will go with them. But, and look, there is no right or wrong answer to these questions, but there are things you need to think about. If you have great caregivers, doctors and specialists and teachers in North Carolina and state benefits in North Carolina, well, what are the state benefits in California? You know, is there a special school there you would want them to go to? These are just things you need to think through. How do they handle stress? We live stressful lives. We just do. You know, financially challenging, time management, emotionally, it's just stressful. Put your potential guardian choice in your situation. You know, the example I always give is, you know, my son has a visceral reaction to certain kinds of music. He'll just start bawling. And, you know, occasionally, you know, we'll be in the grocery store and that song will come over the loudspeakers and he will just start bawling. Well, as a parent, I know we've gone to therapy for this and I help him work through it. Okay, I help him deal with it. I don't remove him from the situation because that's not what our therapists want us to do. Well, it's stressful because while I'm helping him work through it, people are standing around pointing and staring and telling, you know, whispering what a terrible parent I am and what a terrible kid he is. And, you know, my reaction to that, my wife's reaction to that is, you know, this. It's like, move on. There's nothing to see here. We don't care what you have to say. We're going to help our child. How will your guardian react in that situation? Are they going to get stressed out and just remove the child? You know, undoing potentially months of therapy. Again, no right answers. And there are no perfect choices. You know, make the best choice you can. When you talk to your guardians, talk to them about the reality of your life. You want them to say yes to being your child's guardian because they can do the job and they're willing to do the job. Not because, you know, we as parents have, you know, told them about the best day we've ever had with our kid and it doesn't sound so hard. We don't want them to jump into it, realize how hard it is, and then quit or not be able to do the job. And so, you know, be honest with them. You know, don't tell them about your best day. Don't tell them about your worst day. Tell them about your average day. I start my conversations with potential guardians with, I want you to feel free to say no. It's not going to affect our relationship. I'm still going to love you. My family will still love you, but feel free to say no because this is important that you be able to do this if you say yes. Talk to your spouse, talk to your kids, because, you know, if you become guardian of my kid, I want them to be part of your family. So it's got to be a family decision. So choosing a guardian. Prepare your guardian for success, something my firm feels and I feel very strongly about. And that is, write down the things that you do for your child every day, every week, every month, just to make it day to day. You know, tips on sensory issues, feeding tricks, taking medicine tricks, bedtime processes, favorite toys. This is incredibly important if your child has communication issues or an intellectual disability to the point where they can't communicate their wants and needs clearly. You know, obviously write down all the important stuff too. You know, Medicaid numbers, allergies, favorite foods, all of that. But really pay attention for the next couple days, the next week. Every little thing you do, that is not written down. If you don't communicate that to your guardians now, while you're still around, that information will be lost and they will have to relearn it. You know, what took you 10, 15, 20 years to learn, they will have to relearn, and you don't want that. So give them that information now. Write it in a letter. Record it. Do a video recording. Give it to your guardians now so they can ask you questions. I know we're coming up on time here, but the example I want to give you is just meaningful for me, for Kai. And in context, one day, you know, Kai will be at home and mom and dad won't come home. You know, something's happened. And he understands that mom and dad should have been home. So he's getting nervous. He's getting agitated. He sees the guardian walk in. He knows and loves the guardian, so that's okay. But he's still agitated. He's going to start saying swimming goody, swimming goody, swimming goody. And, you know, and on the presentations I give, I always ask people in the audience, anyone have a guess what swimming goody is? And of course, nobody knows. And that's my point. You can't logic it out. Okay, no matter how smart you are, you can't figure that out. Only my wife and I know what swimming goody is until we told our guardians. If he doesn't get swimming goody, which is what helps him calm his system down, that really bad, stressful situation has just gotten worse. So in case you're wondering, Swimming Goody is a specific episode of the Mickey Mouse Club, Mickey's fishy story, about Mickey helping find a fishy friend for Goldfish Goldie. The Swimming Goody to my son is swimming goldfish. So it literally takes me 5 seconds to write that down, get it to my guardian, and that problem is solved. Okay. I'm going to skip past that slide, and we're going to kind of power through the rest here. Major choices and players in your plan, really guardians and trustees are the biggest ones. Guardian is in charge of your child. The trustee is in charge of the money. We do not recommend that your guardian and trustees be the same people. They tend to act as a check and balance on each other. You know, the guardian should be asking the trustee for funds to support the individual. So the trustee has some idea of what's going on. And likewise, you know, the guardian is asking for that money. They have some idea of what's in the trust fund to make sure it's not being stolen or misused or misinvested, you know, whatever the process is. Now, whoever you choose in your plans, you should have one primary and I would say at least 2 backups. You want to spread them out in age, okay? Because again, we're talking about guardians and trustees that might last a lifetime. So if your primary guardian or trustee is 60, see if you can find the next one who's 40 and the one after that who's 30. Now you have a really long lasting estate plan. Make sure that your trustee has a backbone, because if your guardian asks for money and you have specifically said in the trust document you don't want the money used for that purpose, your trustee has to say no to the guardian. So, you know, make sure that the guardian and trustee have a pre-existing relationship. I see people sometimes choose husband and wife for that. That is generally not a good idea. So just make sure they have a good working relationship, but the trustee can say no. All right. One of the big things, and in the beginning, I said I'm going to talk to you about knowing whether the attorney knows what they're talking about and whether they're a good choice for you. One thing they should always talk to you about is how much discretion you want your trustee to have. Okay. If they just hit print on a drafting system in a special needs trust, what it might say is your trustee cannot spend trust funds on things for which public benefits are available. Shall not do it, which means they absolutely cannot. Well, to me, that's not good drafting. I mean, what you want, I mean, unless that's what you want, but I would think what you would want is to give your trustee the flexibility to use it for food and shelter, even if it does impact public benefits. Because the purpose of the trust is to give your child a long, happy, fulfilling life, not to just maximize public benefits. That's a tool to a happy life, okay? So if ultimately, you know, my trustee's been doing great with the funds in the stock market, that fund has grown, and he said, look, you know, I don't want my, you know, the beneficiary in a group home. I want to rent them a nice condo and we'll get services in. Well, if for whatever reason that would reduce his public benefits and my trustee thinks that's in my child's best interest, I want them to have the ability to do. Now we build in safety measures. You know, we make sure that the trustee has to talk to certain people to an attorney, to a benefits planner, to a CPA, to know the impact on public benefits. Point is, you have a choice: full discretion, modified discretion, no discretion. And that choice should be yours, not the attorney's, and not the drafting systems. If your choice for attorney, if they don't ask you this question, you may want to talk to somebody else. Or, you know, if they may have just forgotten, you really like your attorney and they may just have forgotten, you ask them about it. Hey, look, let's talk about discretion because I think that's really important. And it is. Because whatever discretion you give your trustee in a special needs trust will last the entire time after you've passed. It will last for the entire life of the trust. So it's important. Okay. Advanced directive, again, common in any plan. You're appointing your healthcare agent. You're also really making end of life decisions for yourself if you can't make them yourself or your healthcare agent can't make them for you. If you don't have guardianship over your adult special needs child, you will want an advanced directive for them. And of course, everybody should have one. Any adult should have one. Same thing with the financial power of attorney. Who's going to make your who's going to exercise your financial power for you if you're incapacitated? Same thing, everybody should have one. Your adult special needs child, if you don't have guardianship, you probably want to get one for them. Child safety and protection cards, we create these for our clients. And really what this is exactly what it says is, you know, if I'm unable to communicate, please contact the following people. They have the authority and instructions regarding my children. What this is for is to avoid an individual with special needs being, and if something happens to mom and dad and the emergency tab on your iPhone is not filled out, we don't want your kids ending up with a well-meaning neighbor who has no idea how to take care of them, or that you don't want taken care of, or ending up, you know, even in DFACS custody, Family and Children Services custody, even for 30 minutes while, you know, while the authorities look for next of kin or the guardians, right? We want to know exactly, we want the first responders to know exactly who to call. And the people on this list, the first one will always be a spouse, if you have one. And the remainder will be people who are local, who can get to your child in 20, 30 minutes. This becomes even more important if your guardians are out of state and they can't get there very quickly. Okay? Again, we're trying a good estate plan. This plan's for the first 30 minutes, something happens to you, all the way out to, you know, 40, 50, 60 years. All right, a couple words of final advice before I get to the questions. Don't get hung up on picking the perfect guardian or trustee. You have to make a choice. You have to put this in place. If you don't make the choice of guardians and trustees, a judge is going to make it for you. And any decision you can make for yourself is going to be better than a decision a judge makes for you. As Allison said in the beginning, as part of my experience, I work as a judge here in Georgia, and I am telling you that at a guardianship hearing, if you haven't made your choice and it's just left up to a hearing in front of a probate court judge, there's always that one family member who can fake being sane for about 30 minutes. And you do not want your kids with that family member. But if they're persuasive enough for those 30 minutes, there's a chance that's where your kids are going to go. Make the choice yourself. You can always change it. As long as you're alive, you can change it. But put something in place. You don't have to have all the answers before contacting your attorney. Attorneys used to be called counselors at some point. Well, that's because we used to counsel people. So you don't have to have everything squared away. You can come to your attorney and they can help you think through, pros and cons. They'll never make the decision for you, but they'll help you think through the pros and cons of maybe an out-of-state guardian versus an in-state guardian, or this particular trustee. They should ask invasive questions about your trustee and guardian's personal lives, their financial stability, stability of their marriages. Again, more playing devil's advocate, trying to make sure we've looked at it from every angle and they've created the strongest plan for you that they can. Really the other big piece of advice, it's not written down here. To make this manageable, a lot of parents will sit down and look at guardians and trustee choices or money choices. And it gets overwhelming because they're thinking, well, rest of our life, what's going to happen 20, 30 years from now? What I would suggest you do is take a 5-year period and ask yourself, if something happens to us in the next 5 years, what do I want to have happen? And just say to yourself, look, we're going to keep these choices in place for 5 years. You don't have to, but just tell yourself that. Once you have that down, executed in place, and you are protected, you can change your mind. And you'll be surprised, 5 years from now, you'll go back and you'll look at your choices and you'll say, look, those really were good choices and they're still our best choices. Or you can make changes. But bottom line is put something in place. You can always change it later. All right. That's the presentation. I'm glad to answer any questions. I'm going to stop the screen here so I can see the chat box.
DJ, okay. Do you read the questions out to you?
Yeah, if you don't mind.
So we have just a couple of questions. One of them is, if you could let us know the approximate cost range of creating a special needs trust, or let us know approximately the number of hours that an attorney should be charging for drafting a special needs trust.
Okay, so a lot depends on what you're having that attorney create. I have heard that there's wide variations throughout different states. I can really just tell you about Georgia. My firm tends to be, frankly, on the lower end of the scale. For a testamentary trust package, with all those documents that I listed, and a testamentary special needs trust, it's about $3,000. For a standalone trust, a special needs trust with that package, it's closer to $5,000. I've heard of lower in some other states, South Carolina, North Carolina. I've heard lower. I've heard closer to $8,000, $9,000 in California, New York, those areas.
Great. And then another question we have is, what is the amount of money in the special needs trust that makes it so you have to start filing taxes?
So I'm going to punt that to you asking your CPA. I want to say it's something like $1,200. It's not very much, and sometimes it's not even that you have to file a tax return and pay taxes on it, but you do have to file a notification with the IRS every year. So I'm gonna have to punt that one to your CPA.
Great. And then we believe we've answered this, but I just want to confirm that you can have a special needs individual have both a ABLE account and a third person special needs trust?
Absolutely, and I encourage you to actually do that in some capacity, because you do want, they work really well together. So yes, you can have both.
Okay. And another question is that you indicated that money from the trust could be used for ABLE account. Is that for all three types of trust or just one in particular?
So you'll be able to use it with the pooled trust. It depends on the rules of the particular pooled trust you've chosen. For third person, you can. For a first person, you should be able to do it as well. Yes.
Okay. It looks like there's one more. Somebody has asked, some employers provide legal benefits and you can get the trust drafted through that service. How do you fund a special needs trust?
Okay. So I think those are two questions. So the legal benefits, it really depends on your employer. Obviously, some employers have better benefits than others. You really do need to ask for somebody who specializes in this area. The danger is you'll have estate planning attorneys who, we all have drafting systems, okay, that can range anywhere from expensive to insanely expensive. And every one of those systems has a box you can check that says special needs trust. So if you just ask an attorney, estate planning attorney, can you draft a special needs trust? They're going to say yes, even if they don't really have a lot of experience in it. My suggestion to you is ask your employer of the list of estate planning attorneys on your benefit package. Check out their websites and see, is there a section in there that actually talks about special needs trusts? If they just have it listed in one line, I'd say that's not enough. Whether it's worth it. And I will tell you this, those legal drafting systems, if you hit print, what it spits out, will it be legal? Probably. It'll probably be legal. Will it be any good? Probably not. How do you fund the special needs trust? You can fund the special needs trust from anything. I mean, for estate planning purposes, really what you're funding, most of the time what you fund it with, you fund it from your estate. So, for me, it says in my will, if my wife has predeceased me, 60% of my estate to my son's special needs trust and 40% to my daughter's typical trust. Same thing with my life insurance. Life insurance is one of the big ones. A lot of special needs parents, myself included, rely on sufficient life insurance to fund these trusts so it'll last the rest of my son's life. So my life insurance says 100% to my wife. If she has predeceased me, a certain percentage to the special needs trust, a certain percentage to my daughter's typical trust. Those are the major ways. I have not, I'm not a financial planner or advisor, but I have not, even though I have my son's special needs trust drafted, I have not funded it at all because there is no financial benefit to funding it. If I have an extra $1,000 that I want to put away for him, I put it in his ABLE account to take care of take advantage of the compounding tax benefits. So you can fund it any way you want.
Great, and we have one last question. Is the ABLE account state limited, meaning is it transferable from state to state?
You can only have one ABLE account per person. So you can transfer from state to state, but ABLE accounts do cross state lines, much like a 529 plan is. So for example, like my daughter's 529 plan is out of New York. Georgia didn't have an ABLE account till a few years ago, but Ohio's had it for several years. So I know a lot of Georgia families have their ABLE account in Ohio, which is perfectly fine. You just need to find the one that's best for you.
Great. Well, DJ, we appreciate the time that you have taken and for being a good friend to the SATB2 Gene Foundation and to my family, of course, personally as well. I hope that everybody found today's presentation to be beneficial. If you have any other questions, feel free to email me at allison@stat2gene.org, and we'll continue working on providing more webinars for our families. So, thank you, DJ.
Thanks, Allison. Bye.